Several states in the U.S. have passed laws against doctors prescribing gender-affirming care to minors. The legislators in these states claim that gender-affirming care is not something to which children can consent, and despite the fact that the overwhelming preponderance of evidence shows that it benefits the vast majority of kids to whom it is prescribed, they claim that gender-affirming care is something that too many kids will come to regret. Because of the large body of evidence that gender-affirming care is very beneficial to the transgender folks who seek it, including minors, and the fact that it is pointlessly discriminatory to ban it, courts are declaring such bans to be unconstitutional. Here are some excerpts from Brandt v. Rutledge, a recent Arkansas court decision striking down that state's laws against gender-affirming care. One argument that the court refuted was that minors who identify as trans will eventually snap out of it, therefore they shouldn't get hormones or surgery. The court says, the state argues that minors with gender dysphoria will desist with age. They contend that there is a significant risk of harm to a minor who elects to undergo gender hormone therapy or surgery because they will eventually identify with their sex assigned at birth and regret the treatment they sought as a minor. The state offered the testimony of Dr. Levine to support this argument. The court found Dr. Levine's testimony to be inconsistent and unreliable in this area. To the contrary, the evidence proved that there is broad consensus in the field that once adolescents reach the early stages of puberty and experience gender dysphoria, it is very unlikely they will subsequently identify as cisgender or desist. The testimony confirmed that for most people, gender identity is stable over their lifetime. Some of the studies on desisters show that the vast majority of them began to identify as a different gender before puberty. Kids that young don't need to be protected from hormones and surgery because hormone replacement therapy and transition surgeries are not performed on kids before puberty. Even puberty blockers are never administered until after puberty starts. According to the Oregon Health and Science University, your body needs to start puberty before you can start taking medications to block it. They will not work before then. The court continues, there are some individuals who undergo gender-affirming medical treatment who later come to regret that treatment, and for some, it was because they came to identify with their birth-assigned sex, sometimes referred to as detransitioning. This can happen with individuals who medically transitioned as adolescents or as adults. Regret over a medical procedure is not unique to gender-affirming medical care and is common in medicine. There are lots of medical procedures that kids can get that they sometimes end up regretting. How come they aren't all being banned? In Dr. Karasik's clinical experience treating thousands of patients with gender dysphoria over 30 years, none of his patients came to identify with their sex assigned at birth after medically transitioning. Some of Dr. Karasik's patients have halted their medical transition for other reasons, such as lack of insurance coverage or fear of losing family support. Some of these patients later resumed their medical transition. None of his patients who stopped or paused medical transition did so because they came to identify with their sex assigned at birth. Detransition is taken seriously by WPATH, World Professional Association for Transgender Health, and medical providers. Parents and patients are advised of the potential that patients may ultimately come to a different understanding about their gender later in life. The desistance studies relied on by the state to assert that gender incongruence will naturally desist for most youth were focused on prepubertal children and say nothing about the likelihood of gender incongruence desisting among adolescents, the group affected by Act 626. Another argument commonly used is that gender-affirming care is a medical fad pushed by big pharma to increase corporate profits, like the opioid epidemic. The court points out that in the event that doctors are prescribing something recklessly, the state can simply increase sanctions on reckless doctors rather than banning gender-affirming care for minors altogether. The court says the state spent a great deal of time at trial arguing that the number of children identifying as transgender has increased in the last decade, and researchers theorize that the increase could be due to mental illness, social encouragement, or abuse. The state argues that the affirmative model of treating gender dysphoria, which utilizes puberty blockers, cross-sex hormones, and surgeries, allows doctors to throw caution out the window. However, there is no evidence that doctors in Arkansas negligently prescribe puberty blockers or cross-sex hormones to minors. When overprescription of opioids resulted in the opioid epidemic and caused harm to the public in Arkansas, the legislature passed the Chronic Intractable Pain Treatment Act. Rather than categorically banning opioids, the law provides a system of incremental sanctions for doctors who overprescribe opioids, beginning with monitoring prescribing habits, then voluntarily surrendering a DEA license for a period of time, then suspending the physician's license, and finally revoking the license. Doctors have faced discipline for improper prescription of opioids under this section, including monitoring and the surrender of their DEA licenses. If there is a legitimate reason to fear that Big Pharma is pushing gender-affirming care as recklessly as they pushed opioids, which the evidence does not show to be the case, state medical boards can simply apply stricter surveillance rather than outright banning the treatment. The court continues, the evidence shows that the Arkansas Medical Board has successfully navigated the regulation of the healthcare community in controversial areas such as the opioid crisis and gastric bypass surgery. The Arkansas Medical Board is the best option for regulating the ethical considerations as well as the duties of the healthcare community in circumstances like the treatment of gender dysphoria. Some of the laws against gender-affirming care for minors violate the First Amendment. Arkansas's law not only forbids doctors to prescribe hormones and surgery to minors, it also forbids them to refer patients to doctors in other states who could prescribe the treatment. This, the court decided, is a violation of doctors' First Amendment rights. The court says that Act 626 provides that a physician or other healthcare professional shall not refer any individual under 18 years of age to any healthcare professional for gender transition procedures. Dr. Stambaugh claims that Act 626 restricts her freedom of speech by barring her from referring her patients to other healthcare professionals for gender transition treatment in violation of the First Amendment. The state argues that the act targets conduct, not communication by healthcare professionals. In support, the state cites the definition of referral on healthcare.gov. As written, Act 626 clearly regulates speech and not conduct as argued by the state. It prevents doctors from informing their patients where gender transition treatment may be available. It effectively bans their ability to speak to patients about these treatments because the physician is not allowed to tell their patient where it is available. A state may not, under the guise of prohibiting professional misconduct, ignore constitutional rights. Arkansas's law also clearly singles out transgender patients in a way that ignores analogous medical procedures that are comparable to what patients who are not trans can still legally obtain. The court gives the example that the surgical risks of chest masculinization surgery are comparable to the risks related to other chest surgeries adolescents may undergo, including mastectomy or breast reduction for cisgender girls and gynecomastia surgery for cisgender boys. Based on the record, the court concludes that Act 626 prohibits medical care on the basis of sex, and the state has failed to meet its demanding burden of proving the act advances its articulated interests. The court finds that Act 626 violates plaintiffs' right to equal protection. When I was a teenager, I was short for a boy my age, so my doctor recommended I take testosterone to accelerate puberty so I could look more like boys my age. If I were a teenager in Arkansas, I could still get such a treatment today because of the reproductive system with which I was born. However, if a teenager born with a different reproductive system wanted to take testosterone to look more like boys their age, that would not be legal under this law. This unambiguously discriminates on the basis of sex. In fact, when the court in Arkansas blocked the law from being enforced until they made a decision about whether it was constitutional, the state government appealed to the 8th Circuit Court of Appeals to allow them to enforce the law while the proceedings were ongoing. And the 8th Circuit decided to keep the injunction against enforcement in place because they believed that the plaintiffs had a reasonable chance of success due to the fact that this law is clearly discriminatory. This appeals court is made up almost entirely of Bush appointees and Trump appointees. Right now, there is only one judge on that court appointed by the Democrats, so nobody can claim that this decision was due to political bias. The 8th Circuit said, under the Act, medical procedures that are permitted for a minor of one sex are prohibited for a minor of another sex. A minor born as a male may be prescribed testosterone or have breast tissue surgically removed, for example, but a minor born as a female is not permitted to seek the same medical treatment. Because the minor's sex at birth determines whether or not the minor can receive certain types of medical care under the law, Act 626 discriminates on the basis of sex. The Arkansas court found that the law also violates people's due process rights. They said the liberty interest at issue in this case, the interests of parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interests recognized by this court. Parents' substantive due process right to make decisions concerning the care, custody, and control of their children includes the right to direct their children's medical care. Conservatives love to talk about how much they care about parents' rights with respect to decisions they make about their kids. You would think that such rights would include the right of parents to give their child medical care that their doctor prescribes. They say they want small government and parental control over their kids, but then pass laws that get in between families and their doctors and take control away from parents. The Arkansas court says the state has failed to present evidence that the gender-affirming procedures banned by Act 626 jeopardize the physical or psychological well-being of a minor with gender dysphoria. There is no evidence that the Arkansas healthcare community is throwing caution to the wind when treating minors with gender dysphoria. Moreover, the evidence shows that the Arkansas Medical Board has successfully navigated the regulation of the healthcare community in controversial areas such as the opioid crisis and gastric bypass surgery. The Arkansas Medical Board is the best option for regulating the ethical considerations as well as the duties of the healthcare community in circumstances like the treatment of gender dysphoria. Fears about kids catching some social contagion that brainwashes them into getting hormones and surgeries that many of them will regret are simply not borne out by the evidence. The sad irony of laws banning gender-affirming care is that they do the opposite of what they claim to do. They don't protect children from harm, they subject children to harm. The court says, rather than protecting children or safeguarding medical ethics, the evidence showed that the prohibited medical care improves the mental health and well-being of patients, and that by prohibiting it, the state undermined the interests it claims to be advancing. Further, the various claims underlying the state's arguments that the act protects children and safeguards medical ethics do not explain why only gender-affirming medical care, and all gender-affirming medical care, is singled out for prohibition. The testimony of well-credentialed experts, doctors who provide gender-affirming medical care in Arkansas, and families that rely on that care directly refutes any claim by the state that the act advances an interest in protecting children. Another irony of these laws that so many states are passing is that their advocates sometimes claim that they are protecting children from a medical and social fad. But it is these laws themselves that pander to the political fad of making scapegoats of transgender people. To everyone who helps me out on Patreon, you're a big help. Thanks so much.